everyone, and welcome to tonight's talk. I'm Nikki Welly from the Kellogg Hubbard Library, and we're pleased to be partnering with the League of Women Voters for this series. Before we get started, I'd like to let you know that this meeting is being recorded. Please remain muted throughout the presentation to ensure the best experience for all participants. If you have questions, please type them into the chat, and our moderator and speaker will address them. Now, I'm excited to pass it over to Kate, who will introduce tonight's moderator and get us started. Kate?
Good evening. Forget I have to start talking. I'm Kate Reeder with the League of Women Voters, and I'm really pleased to open this 10th anniversary series of our partnership with the League of Women, with the Kellogg Hubbard Library. Tonight we are discussing Birthright Citizenship as part of our series on voting rights and access to the ballot. Tonight, our moderator is Paul Earlbaum, a member of the League. He is the League's appointee to the State Ethics Commission and is the current chair of the commission. And Paul will introduce our speaker tonight. Paul?
Thank you, Kate. Hi again, I'm Paul Earlbaum, and I'm delighted to introduce Julio Thompson, somebody I've known for several years. And in addition to being just a really good person, Julio is an assistant attorney general for the state of Vermont, and he's the co-director of the Attorney General's Civil Rights Unit, which enforces Vermont's laws regarding employment discrimination, fair employment practices, and hate crimes. And in that role, Julio also represents the state of Vermont in national civil rights litigation and testifies regularly before the Vermont legislature on issues relating to employment law and civil rights. Julio spent his first 15 years of practice in Los Angeles, first as a judicial law clerk for the U.S. Court of Appeals for the Ninth Circuit, and later as a partner in a downtown LA firm where he specialized in labor, employment, and civil rights law. So, and I'll just remind everybody to, yes, please write questions in the chat if there are any repetitions. I'll curate them and pose them to Julio when he's done with his talk, or I might interrupt Julio. But for now, Julio, why don't you take over?
Sure, thank you. Does everyone hear me okay? Is the volume suitable for everybody? Okay. So good evening, everybody, and thank you for showing up. Working in the Attorney General's office in the Civil Rights Unit, part of our responsibility is not only to enforce Vermont's laws governing various aspects of civil rights, including employment and protecting people from bias-motivated crimes or other kind of harms. We also may get involved in cases of a national scope where there's an impact that somehow goes back to Vermont. So something that might be happening in Congress or out of the White House, or a response to something coming out of the Supreme Court, where there's some impact on Vermont that affects how we live, how we raise our families, and the like. And and that can span any number of subjects. Going back to when I first started in the AG's office, we were in court over greenhouse emissions and how that would affect the state of Vermont. We were in cases involving food labeling to let people know when they were buying products that were genetically engineered or modified. And we've been in court for a lot of different reasons, some relating to things like another one that's come up recently is facial recognition, where people are scanning pictures off of the internet and trying to generate a database of everybody's face and then trying to sell that information to the highest bidder. So we have for a long time under many different AGs been involved in that. Tobacco litigation is another one that Vermont is known for being an early leader in the 1990s. And and currently, circling back to the topic today, birthright citizenship, which really has relevance because of a January 20th executive order that President Trump signed a few hours after he took the oath of office. There are a fair number of lawsuits that we have filed that have challenged actions by the executive branch in a large part. So President Trump or some of his agencies like Homeland Security or the State Department that affect the civil rights of Vermonters, that affect directly how we live, and also that have equal importance to people nationwide. I think currently, state of Vermont has, I should have counted before we started, I think we're over 35 different lawsuits we have filed against the administration since January. A lot of those cases are seeking an order to block what the administration has done. In many cases, the administration has done things that only Congress can do, or he's attempted to do things that only Congress can do. And so those violate the separation of powers, where the president's exceeding his own authority. And in some instances, they involve some kind of bias element. So we either are suing directly or we are filing briefs in cases where Vermont is not in the lawsuit, but is providing briefing to the court on issues that are, we think, important to the issues and also important to Vermonters. And those extra briefings are called friend of the court briefs. I think our number is probably, we're in 35 plus lawsuits. We're well over 50 friend of the court briefs that we've joined or in some cases co-wrote with other states. Many of these cases are multi-state. So in the birthright citizenship case, for example, Vermont is in that lawsuit with 17 other states, as well as the city and county of San Francisco. And I'll talk about that lawsuit in a bit. But so that's part of the function we have of our office, is to have lawyers who work on some of those cases. We have a division that deal with court appeals all of the time. And they are doing, I would say, the lion's share of that litigation. The Civil Rights Unit is doing a select number of cases. Birthright citizenship happens to be one of them. It was actually the first case we filed, which was the day after inauguration, a day after the order issued. So it's in that context that I'm talking with you today. During the prior Trump administration, I was also Director of Civil Rights then. I think our office during the first administration, filed, I believe the number was 62, or joined 62 separate lawsuits. We were very successful overall. We prevailed in 60 out of the 62 cases. And in the second administration, I would also say we have a very strong track record. We are blocking a lot of the unlawful orders. We're sharply limiting them. They're still on appeal at various stages, but so far the picture seems to be very positive. So tonight we're going to talk about birthright citizenship. I'm guessing you signed on because you've heard something about it or read something about it, or maybe you read a lot about it. If there are any historians in the group, I'd be interested in hearing questions that relate to maybe some of your background and reading. To work up this case is involved. I think anybody who's been working on the case has had to read a lot of U.S. history, go back to the 19th century, go back to the Civil War, or even pre-Civil War era, really, to get a sense of where this issue comes from. So I'm going to start now and transition into talking a little bit about the laws that are at issue in birthright citizenship. And really, we have to go back to the 1850s. before the Civil War started to a case involving a court decision involving the question of whether an escaped slave, Dred Scott, upon freeing his state where he was enslaved, going to a so-called free state at the time, did he enjoy the rights of U.S. citizenship? Was he, because he had been born in the United States, he was not brought here from Africa or any other country, but was born in the U.S. And so the question was whether Dred Scott was a slave, and perhaps one of the worst and certainly one of the darkest days of the Supreme Court held that he was not, that slaves born in the United States were not U.S. citizens and did not enjoy the rights of citizenship. And we'll talk about what all those rights are. Voting obviously would be one, but not the only one. Following the Civil War, Congress passed the 14th Amendment in 1868, and that is the amendment of the Constitution that addresses the question of who is a citizen or who can become a citizen in the United States. To put it in context, the 13th Amendment, which was passed in 1865, abolished slavery. The 15th Amendment, passed in 1870, gave men over the age of 18 the right to vote. Of course, it'd be another 50 years before women gained the franchise, as you all know. But in between those was the 14th Amendment, which talked about the basic rights that that people who were born in the U.S. or who later emigrated to the U.S. and became lawful residents, what rights they were entitled to. And the very first sentence of the 14th Amendment in Section 1 says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. So the 14th Amendment not only decides who's a U.S. citizen, but it decides which of the 50 states you are a citizen of. And the question that's before the Supreme Court now, and it's been litigated before, but not recently, is just, what does it mean to be subject to the jurisdiction of the United States? That's really where all the arguments arise. If you have people visiting, let's say people are visiting Vermont from, I don't know, from the United Kingdom. They want to try their hand at skiing or snowboarding. And while they're here, the mother gives birth to the child in Vermont. What is and both of them, the parents are citizens of the UK, nationals of England. What is the status of that child? What does it mean? Are you automatically a citizen or not? And is that different than if the parents were diplomats who were visiting the U.S. on a diplomatic mission and the child is born there? Or whether, to use maybe a more outlandish example, but one that courts discuss when they're analyzing this language, is what if they were part of an invading army and they had invaded the United States and the child is born there? Is that a U.S. citizen or not? And so that's really the question, is what does being subject to the jurisdiction of the United States mean? And before I dig too much more into the 14th Amendment, I want to talk about the executive order that came out on January 20th. Like I said, a few hours after the president stepped off of the dais where he took the oath of office and signed the executive order. I want to talk about what that executive order said and what impacts the executive order would have if it went into effect. So on January 21st, President Trump signs an executive order that says that birthright citizenship, and generally that refers to you being a citizen if you're born on U.S. soil, regardless of your parents' immigration or citizenship status. And the executive order says that you do not get citizenship if you are born here and either your mother is here and she's undocumented, she's not here lawfully, or she's here lawfully, but she's visiting. Either she's got a visa, or she's a tourist, or she's otherwise authorized to be in the U.S. So if she's not here to stay, essentially, she's here, or she's here to stay, but she came here unlawfully, and your father's not a citizen, or your father's not a long-term permanent resident of the U.S. That means they've gone through the lengthy process to become a permanent resident in the U.S., also known as a green card holder. So if your mom's not here lawfully, or just she came here temporarily, and your dad isn't a U.S. citizen, isn't a long-term permanent resident, then you are not a U.S. citizen. And that is contrary to how the United States has treated such children. The basic rule, again, with some very minor exceptions we'll talk about, is that if you're born here, you're a U.S. citizen. The order was not retroactive. It didn't go back in time. Some other countries have done similar things and gone back retroactively to wipe out the citizenship of other people. The Dominican Republic did something like that. The Supreme Court did a little over 10 years ago, and it's created absolute chaos in the Dominican Republic. But this executive order said that basically anybody born in the U.S. on or after February 20th, so a month after the executive order was signed, would not have U.S. citizenship if their parents, if the father wasn't a citizen or a green card holder, and the mother wasn't here lawfully or was here visiting temporarily. And the effect of that order, if it were to go into law, would be to really strip people born here thereafter of a fundamental right to citizenship, which entitles you to many things, including the right to vote, the right to hold public office, the right to hold any of hundreds of thousands of federal jobs, as well as receive any number of benefits ranging from Medicaid to other sorts of benefits of if you have one or more disabilities. So there's a lot of financial benefits in the United States that have, by act of Congress, only been limited to U.S. citizens or lawful permanent residents. And so with the stroke of the pen, the president sought to strip, that right for a lot of people who otherwise would have enjoyed that and have enjoyed it for over 150 years. And the impacts on the state of Vermont would be almost immediate. Right now, and for the last century and a half, how you get a social security number is determined basically by what hospital you're born in. You provide a birth certificate that's sent from the hospital to the Social Security Administration. And they say, well, you're born in Vermont. Okay, you get a social security number because you're a U.S. citizen. The executive order would make that a lot more complicated. It doesn't matter where you're born. It matters what your mom's status is and what your father's status is. And not everybody's born in a hospital. And so it would immediately create chaos for the states, and that they'd have to do a lot more work to figure out who gets a social security number or not. And that's going to cost millions of dollars. And the executive order doesn't tell states how they're supposed to do that. They're supposed to kind of figure it out. it would also almost immediately raise your taxes as Vermonters, because people who are here, were born here with foreign-born parents, and who were not eligible for Medicaid or Dr. Dinosaur or any number of federal benefits, to have support and to remain housed and out of poverty, would have to get those payments and that support from the state of Vermont, which would have to raise the state income tax to try to backfill tens of millions, even in some cases, hundreds of millions of dollars of federal supports that are paid for by the U.S. You know, the money, the federal pot is paid into by 50 states plus D.C., Puerto Rico, and other territories. So it would be an immediate burden on the state of Vermont, as well as, the obvious stripping of rights from individuals who are born from now and into the future. So knowing that, the state of Vermont, the day after the executive order was signed, took the Trump administration to court. We joined, as I mentioned earlier, 17 other states and the county and city of San Francisco, and filed a lawsuit in federal district court in Massachusetts. At the same time, there was another group of states that was based out west, led by the state of Washington, that filed suit out on that side of the country in a different judicial circuit. There were also lawsuits that were brought up by nonprofit organizations representing immigrants, representing at that time pregnant parents who were facing uncertainties about what the legal status of their children was going to be. So there were multiple lawsuits that were filed. In our case, as I said, we were able to file the very next day. That's because we knew it was coming. President Trump and people involved with the so-called Project 2025 were quite vocal the year and even prior to 2024 that this was one of their goals. And so there were a number of states, Vermont included, who had begun preparing for that. I think I started looking at birthright citizenship just myself about the spring of 2024, when President Biden was still running for office. We were doing a lot of research about what would happen just in case the election went the other way, because we were expecting a lot of action very quickly. And if it was anything like Trump 1.0, we were expecting a lot of those actions would violate the law, as indeed they have. So we were able to get into court very quickly. And we were seeking, when you file a case in court, the court case may take a year or two to complete, but you can seek a temporary order asking the court to just freeze everything in place, keep the status quo, until you can decide whether the president can do that. And that's through a court order that's called a preliminary injunction. An injunction is just an old-fashioned name for telling someone to do something or not do something. And so we were seeking an order for the court to tell the Trump administration, do not stop giving Social Security numbers, do not stop recognizing newborn children as as citizens, until we can sort this all out. Until we can the court can have an opportunity to get all the evidence and briefing before it. So we filed on January 21st. About 3 weeks later, the court, in our case, issued the preliminary injunction on February 13th. And basically since February until today, the administration has been frozen in place. They have not denied citizenship to one child born after February 20th. They are continuing to issue Social Security numbers, and have been in all of the states. The court issued an order against the Trump administration that applied to all to all of the United States, what we call a nationwide injunction. So it wasn't just the 17 states that would benefit from that. It was the residents and all 50 states and DC and Puerto Rico and the territories. And that case has been going on in court. After the district court, the next level before the Supreme Court is the U.S. Court of Appeals, which for us is for Massachusetts, where we filed the lawsuit. That's the First Circuit Court of Appeals. And on October 3rd, the Court of Appeals agreed with the district court that the injunction should stay in place, that the Trump administration had gotten the law wrong, that the executive order was unlawful. And now we are anticipating shortly that the administration will ask the U.S. Supreme Court to take a look at that. I would expect, based on what's happened thus far in the case, the Supreme Court will take the case to review. My guess is that the earliest we would know for sure would probably be January. I think in January 2026, we're very likely to get an order from the court saying, okay, we're going to consider the question and do that for the entire country. I don't know if we've had, Paul, I haven't looked at it, see if we have any questions along the way. I'm happy to address any along the way before I shift gears and talk about the history of the 14th Amendment and how that compares to today.
There is one question that's come up in the chat. I'll just read it off. If a baby born here is not considered a citizen, what is his or her status? Are they considered illegal immigrants who could be deported?
That's a great question. And it's a question that the United States has been asked by I shouldn't say many, several judges in the different court cases. Like who are these children? Are they stateless in effect? And we really haven't gotten, I would say, a very satisfactory answer. It sort of depends on the status of their parents, because if the parents are here lawfully, let's say like the mother is here temporarily and the father is also here temporarily, they're both on student visas, they wouldn't be subject to deportation right away. The parents wouldn't be. But visas usually have expiration dates. And so the question would become if the parents didn't renew their visas, or they wanted to apply for another visa while they were waiting, what happens to Junior, the baby, what happens to the baby? And they haven't really provided a very good answer. In other countries that have different standards for immigrants, they are called stateless children, and there are quite a few countries that have a different standard. It isn't tied to being born on their soil. It really has to do with their lineage, where their parents are from. I looked at this earlier in the year when we were considering this question, what happens to the kids? And I think, the best information we have comes from 2023. It's some report put out by the Annie E. Casey Foundation. It's about 12 million kids around the world that are considered stateless, and therefore they have no right to vote, and they're often do not have basic rights to education in those countries or government supports. So yeah, it isn't. I wouldn't say it's a very well thought out. I think the purpose of the policy is that if parents see that their child doesn't have legal status, is to create an incentive for the whole family to leave. I think that's the challenge. The difficulty with that is that there are millions of mixed status households in the U.S. where depending on when the child was born, even under this executive order, they may have other children who are U.S. citizens. And so you have what we kind of call the quiet family separation, where some people are required to leave, and the question is, does the whole family leave, or does a family get torn apart because maybe the country of origin is dangerous? Just this week, we are joining some other states and filing a brief dealing with the threatened deportation of Venezuelans and Haitians who have lawful temporary status here, but the administration is trying to cut it short. In the meantime, they've had kids in the U.S. who are citizens, and the question becomes: does the whole family, you take your kids back with you to a country? Both countries are considered too dangerous for U.S. citizens to be recommended travel. They're both in what's called Category 4, so marked by kidnappings, federal corruptions, random violence, human trafficking, and the like. So it's really not clear. And it's part of the reason why we are fighting this, is just so that people can continue to have the expectation, as they've had for over 150 years, that if you're born here, you're basically a citizen. So what I'd like to do is talk a little bit about jumping back to the 19th century and talking about the 14th Amendment and how that was originally interpreted. What does it mean to be subject to the jurisdiction of the United States? And jurisdiction can mean different things under different contexts, but generally, if you're subject to someone's jurisdiction, you are bound to follow their laws. And that's kind of the common understanding of jurisdiction. So if someone's visiting, to use the couple from the UK as an example, they're not citizens of Vermont, they're not citizens of the US, but if they come here, they have to obey the Vermont traffic laws. The federal laws against, governing bank robbery apply to them as well, because they are here and they're subject to US law. That's kind of the general common understanding of jurisdiction. And so if you have two parents who come here without legal documentation, or they were here legally, but their visas expired, so they're overstaying their legal authorization to be here, they're still bound to follow the US laws, or they're going to go to jail. And so the question is, if the baby is born here, does that baby subject to US law? They won't be driving, obviously, or robbing banks, but are they also entitled to basic rights guaranteed under state or federal laws that are available to citizens? And the Supreme Court has looked at this question before. They did it in a case that was called Wong and Kim Ark, that I'm going to talk about a little bit, and I think it'll set the stage for it. So Wong Kim Ark was born in San Francisco in the 1870s. His parents had been born in China, but had lived for many years in the U.S., where they had a family business. And then when Wong Kim was a teenager, his parents went back to China. And Wong Kim later on actually visited his parents twice in China. The second time he came back, there were different people in the federal government, working for the, there was kind of different administration, and they held him up at the Bay, the Bay at San Francisco Bay, questioning whether he was allowed to come back into the country, because Congress had passed one of many awful, really racist laws that they passed in the 19th century and early 20th century that were anti-Asian. That was called the Chinese Exclusion Act. And they said, well, your parents weren't citizens when you were born here, and their loyal to the government of China, and you went to go visit China. So we don't think you can come back. And so Wong Kim Ark, who was a laborer by description, he wasn't college educated, didn't have financial resources. He did challenge that in court, and it went to the U.S. Supreme Court, which read that language: "You're born here, and you're subject to the jurisdiction of the United States." And it read it. It read it in the context of the common law from England, that the U.S. Constitution kind of imported from England. And in England, the common law just means it's decided by courts rather than legislature. There was something that was called use, and that's with a J, so it looks like juice, J-U-S, solely, the right of the soil. So there had been a long-standing tradition in English common law that if you were born in England, regardless of where your parents came from, you were subject to the authority of the crown and you were a citizen of England. And that's what jurisdiction meant to the people who, wrote the Constitution, and that is the history that was kind of imported into the Constitution. And so the Supreme Court, bottom line, said, yeah, if you were born here, doesn't matter where your parents are from, you're a U.S. citizen. There were a couple of exceptions that the English had recognized. One was if your parents were part of a foreign army that had invaded England, that had been a court-created exception. Another one was if you were the child born of diplomats who were visiting England, you were excluded. And the Supreme Court added a third exception in the Wong Kim case, which had to do whether people who were Native American, who were born in the tribal system. So if someone was, let's say, part of the Sioux tribe and they were born in the United States, whose jurisdiction were they subject to? At the time, in the 1860s and 1880s, around that period of time, they were considered only subject to the authority of their tribe. And so under the Constitution, in an earlier case, the Supreme Court said that so Native Americans born on U.S. soil were not subject to the jurisdiction under the 14th Amendment and not automatically citizens. That changed in the early 20s. President Coolidge signed a law, an act of Congress that conferred citizenship on Native Americans, but it wasn't done as a constitutional right. And that's basically the law since then, has been that you're born here and that's what counts, putting aside those exceptions for foreign armies, diplomats, and the like. And there have been a whole bunch of court cases over the last 150 years where the U.S. Supreme Court has repeatedly interpreted the 14th Amendment to embrace birthright citizenship. There have been cases where both parents came across without any authorization. Their child was born here, child's a U.S. citizen. Another case where it was discovered that the father had falsified papers saying that he had certain job skills, and so he got into the country by virtue of fraud, and their child was born here. The U.S. Supreme Court said, doesn't matter, your child was born here, your child was born subject to the jurisdiction of the U.S., and that's that. Most recently, I think the most recent case was kind of a post 9/11 case involving what rights do people who were suspected of being part of Al Qaeda, were detained by the U.S. military, either in Guantanamo, Cuba, or offshore in the U.S. What were their rights? And there was a case involving someone who had been, captured in Afghanistan. He was of Afghani and I think Syrian descent, but he was born in Louisiana. And the question was, did that person have due process rights that were, and he was being detained outside of the U.S. territory. He was being detained in a naval ship, actually, off the coast of South Carolina. And the question was, what rights did he enjoy? And in the briefing for that case, someone made the argument that, well, his parents weren't lawful permanent residents, so he's really not a U.S. citizen. And the Supreme Court in that case, which was as recent as that was a 2004 case, brushed that aside and said that, yeah, we're treating him. He is a citizen, and we're going to decide the case on that basis. So it's pretty much been an unbroken line of Supreme Court cases for the last 150, 160 years, plus many other lower court decisions holding that if you're born here, that's what counts. And so why is the government arguing otherwise? Why make the argument? What is the argument? Well, going back to the Wong Kim Ark case, the U.S. Supreme Court case in the 19th century, the decision, only 8 justices out of the 9 participated in the case, and the decision was 6-2. So there were 2 justices who were not convinced that this jus soli, this right of the soil, actually, applied to the United States. And they had various arguments for that, these 2 justices. One was that, well, the United States made a deliberate break from England, right? Declaration of Independence and all of that. And in cases dealing with Indian tribes, this justice said, we previously talked about, well, if someone is born, let's say, of the Sioux Nation, they don't have any duty of allegiance to the United States. Their duty, if they've exhibited any duty, it's to their tribe. And so they interpreted the phrase "subject to the jurisdiction" to mean that you owe a duty, or your parents owe a duty of allegiance to the United States, which is more than just following the laws. It's more than being subject to getting a traffic ticket or getting arrested if you break a U.S. law. And the Trump administration has tried to revive that argument that was rejected in the Wong Kim Ark case, and has been continually rejected, but that's the arguments they're trying to make. I think there may be another question.
Yes, one just popped up. I'll read it to you now.
Sure.
Do you think the Supreme Court, as it is now constituted, will maintain birthright citizenship or not? Could they send this to a shadow docket? And you might want to explain, what is a shadow docket?
Sure. With no justification. So, one, I can't tell you, I don't know what the Supreme Court's going to do. So the shadow docket really refers to decisions that the U.S. Supreme Court makes on a lot of, there's a big shadow docket because there's so many lawsuits against the Trump administration. And so what happens is, remember I said earlier on, you can seek a court order to kind of freeze everything. Let's maintain the status quo and let the lawsuit proceed. And then, Trump administration, if you win, then you can do whatever you want to do. But right now, there's less harm if we just keep things the way they are. And Trump administration, when they lose those, and they lose many of them, they go to the Supreme Court and ask the Supreme Court to overturn that and say, we want to keep doing what we want. We want to start doing what we want to do. And then if we lose the case, they'll have a remedy. So they argued here, they did, they could argue in this case. They haven't done that in this case, but they could argue, for example, well, let us start denying Social Security numbers, because if we lose, we'll just issue them. We'll just issue them later, so they have a remedy. So, but in the meantime, we want to figure out how the thing's going to actually operate. So that's often called the shadow docket, because those appeals to the Supreme Court, that's term I'm using loosely, but those appeals happen very quickly without a lot of briefing. And they happen often under very urgent circumstances. If you've been following the news and following like the Abrego Garcia case, for example, where the Trump administration is trying to, is putting somebody in El Salvador despite a court order saying he shouldn't go to El Salvador. We're trying to fly people off of U.S. soil. Someone files a motion with the Supreme Court at 11 o'clock at night saying before 7 a.m., we need an order from you. And the court might say, okay, stop everything, or we're not going to stop everything. Maybe we'll stop it tomorrow, but we're not going to stop it tonight. That's often called a shadow docket because it's not fully briefed. There's no oral argument in front of the court. Often the court has very abbreviated reasons for its decisions, and so it's been called the shadow docket. It's sort of a creature, in part at least. I don't think the court likes doing that. Supreme Court used to, enjoy the summer off. They would recess at the end of June and not come back until late September, early October. But they keep getting all of these last minute, midnight applications for court orders that do present real emergencies. And so that's what the shadow docket is. And do I think that, so there's two questions. Do I think they would send this to the shadow docket? I think there's no chance of that. I'll talk a little, this issue, the case is in part already been in the Supreme Court on a very narrow but important issue. And listening to the oral argument from the justices in that case, I'll talk about in a little bit. They're eager to get to the merits of this. And both sides of, the kind of, if you have a view about left or right, judges, politically conservative or judicially conservative, justices of all stripes are interested in getting this case. And they're going to decide the case. Will they maintain birthright citizenship or not? I can only offer our view. We're right. We are right. And the Supreme Court got it right over 150 years ago. We think the half dozen or so Supreme Courts that have considered this issue over the 20th and into the 21st century got it right as well. And so I can't give you a vote count, but I feel pretty confident in our chances. As confident. There has been no court. So many judges have considered this issue and all of these different court decisions, and from for maybe 5 different presidents. So if you're thinking about this is an Obama appointee, we try not to look at things that way. But there's been no judge who's considered the issue who thought the case was even close for the government. The First Circuit I mentioned earlier gave us an opinion on October 3rd. Its opinion was 100 pages. But in the first paragraph, the court said, this is a long opinion, but it's because the government and the opposing arguments have offered so many arguments, we have to go through all of them. But you shouldn't mistake the length of this opinion for whether we think this is a close call, because it's not. So my view, and I think our view, and I think the better view, and the historically aligned view, is that it's not a close call. Long answer to a short question. So I guess what I want to talk a little bit about is what's really at stake. What are the benefits that would come into question if you're denied citizenship? First of all, the state of Vermont, and as well as the families, would lose immediately Medicaid funding through the CHIP program. CHIP is the Children's Health Insurance Program. And that's for families that are living below the poverty line or near the poverty line. What happens is that those benefits by law are only available to lawful permanent residents and U.S. citizens. So these children would not be entitled to those benefits. There's another federal law that's called IDEA, the Individuals with Disabilities in Education Act, which require the states to provide a lot of resources for children, really starting from infants through their education, that would where they need early intervention, they need additional educational resources. And under that federal law, the federal government reimburses a lot of that money to the states. So that money would be gone for all of those kids who were born in the U.S. where their parents don't meet the narrow categories of the executive order. There's another set of laws under the Social Security Act that have to do with funding for foster kids, adoption programs, and guardianship programs. And basically, the effect of the executive order, if it were to survive, would be to create a second-class citizen, a second-class system where you would have kind of a tier 1 foster program where kids are getting federal support, and tier 2 where they're not. And the question becomes, and Vermont may try to fill that in, but you can't expect that other states would. And it also affects Vermont. In the Vermont perspective, it affects all sorts of different resources that we receive. That's based on the number of residents, and then the number of citizens we have for different types of benefits. And it affects, as we go into the future, it's going to affect who can vote in the country, and who can run for office, because, like I said, the 14th Amendment not only addresses citizenship of the United States, but also of the states. So Vermont has a very direct stake in that, and that's important for us because when it's kind of a background fact I really didn't mention, because maybe it's too in the weeds. I apologize if it is. But when the state of Vermont sues, we go to federal court. We have to demonstrate, in order not to be thrown out of the courthouse, we have to demonstrate an injury to the state, not an injury to individuals like the kids, because the courts say, you know what, those kids, their families or someone representing the class of kids in a class action, they can go to court. So why does the state of Vermont get to sue? Why do they get to go to court? And so we have to show an injury to the state of Vermont. And often that's in terms of additional costs that we have to bear. We'd have to create a brand new system for sorting out Medicaid benefits, right? Because we couldn't just take a birth certificate and say, okay, your kids are U.S. citizens, and so you get this additional benefit. We would have to have some other unknown mechanism, and that can be very hard. Where you have in many cases where you don't know where the parents are, or you don't know where one of the parents are. And so, how do you ascertain the citizenship status or immigration status of dad if dad's not in the picture? So it would cost the states a lot more. And so, when we went to court, we had to demonstrate to the judge that we belonged in this case because Vermont was going to have to pay a lot more, was going to have to bear a lot of the costs of this unconstitutional executive order. So, and the courts have agreed, and I think it's likely that I don't think there's any real serious argument anymore that it really would cost a lot to the economies of all the states, putting aside, the affront to civil liberties that obviously, is kind of the main stake in the case. So I'm going to pause there and see if there are other questions, or if people have other questions, or Paul, if there's anything I haven't covered that you think I might want to address, because I've been talking forever, it feels like.
I have a couple of questions, but let's just make sure to invite everybody to pose a question in the chat. I'll take a look there, but actually, I wouldn't mind, Julio, if you don't mind going back to the 1860s. And why was the birthright? What were the policy considerations to put in birthright citizenship at that time in the 1860s? Why create that part of the 14th Amendment?
Um, I mean, that's a question that that Supreme Court will ultimately have to address. Um, the government's argument, it's kind of easier. Um, it's kind of easier to get into that by looking at the contrary argument that the government's making. So the government's argument is this: hey, the 14th Amendment was a post-Civil War amendment. It was really focused on slavery and the horrible economy of enslavement. And it was really focused on African Americans. The Supreme Court wasn't thinking at all, or I'm sorry, the Congress, when they passed the 14th Amendment, and the states, when they ratified it, they weren't thinking at all about immigrants. They were thinking about the rights of freed people or people who had formerly been slaves. And so, therefore, you shouldn't take it beyond that. That's the argument. And the idea is that the policy argument they advocate is that if it's not a constitutional requirement, then Congress or someone else can set the policy. And we can do that we can do that now. We can change it a lot more easily than we can change a constitutional amendment. There's only been one constitutional amendment that's been repealed in our history. On the other side, what the court did was just say, well, what does subject to the jurisdiction mean? And that's a phrase that we see in our law. And when we go back, even in the United States history, to like cases decided in 1812, they were talking about subject to the jurisdiction means that you could be, that the either the state or the federal government's laws could apply to you. And where did that come from? The Constitution, 1789. So it's like, well, that same phrase was used in England for several centuries. So why would we think that it would mean something else than other than what we would do it? And that's kind of a standard for judicial interpretation, is if you use a term, what does that term historically meant? And then the court says, well, since you didn't include a definition, we're just going to look at how it's been interpreted in the past, and that's how we'll get to that meaning.
So I have a dumb question to ask, Julio. So can birthright citizenship be eliminated by a presidential executive order?
No.
Could you be clearer?
No. Yeah, okay. I mean, I was almost going to say in the interest of brevity, but I haven't been brief. But, in the cases, it's not just the 14th Amendment. In 1940, Congress passes a number of laws governing all aspects of immigration. Who can come here, under what circumstances, what a visa is, how long they last, and so forth. And in 1940, one of those laws that Congress passed was really trying to address the issue of people who were born in tribal births. Because I said earlier that people who were born through subject to Native American, if they were subject to their tribal system, they were viewed as kind of their own sovereigns, not subject to the authority of the U.S. In 1940, Congress changed that and said, if you were part of the Sioux Nation, you're born in Oklahoma, you're still part of the Sioux Nation, but you're also a U.S. citizen. So they expanded that, but they also included the same language that was in the 14th Amendment that said that if you're born on the U.S. soil and you're subject to the jurisdiction, you're a U.S. citizen. So Congress has already passed a law on that, and that's important to your question, because the president can't, with an executive order, undo an act of Congress. Period. Most of the cases that we've won against the Trump administration has been where the executive has tried to do something that's contrary to what Congress can do, and that includes holding up federal spending and imposing his own conditions, right now, last week, the Supreme Court heard argument about whether the president's tariffs are usurping Congress's role. And I feel pretty good that I feel personally pretty optimistic the court will say that he couldn't do that either. So no, he can't just undo it with the stroke of the pen.
All right. I don't see any more questions in the chat, but I have one. But folks, again, feel free. But I'll launch forward just to say, Julio, you mentioned briefly that this birthright citizenship was before the U.S. Supreme Court, but they didn't deal with the substantive issue, did they? They did something else that was important, and you said it was important, but would you just
Yeah,
describe that a
yeah,
bit?
yeah, sure. So I mentioned earlier that when we went to court and got a court order blocking the administration from doing that, the order that we sought was going to apply to the entire United States. And what we did was we said, because the executive order basically says you aren't a U.S. citizen, and therefore the president is talking to his own agencies. So therefore, Social Security Administration, do not issue Social Security numbers to this new class that I'm creating with this executive order. And so we said that was unlawful. And the effect of that was, even though 17 states filed in court in Massachusetts, a federal judge sitting in Massachusetts issued an order that applied to all of the United States. And a similar court on the West Coast did the same thing, kind of looking eastward, and said it's illegal. It's got to apply to the whole country. The administration asked the Supreme Court on one of these kind of rush basis, said, you know what, we want to challenge the ability for one case to bind the whole country. And so they wanted the court to say, yeah, Vermont and New Jersey and the other states who joined that lawsuit, you guys won for now. And the court's order should be only for you 17 states. But Texas doesn't have a problem with what we're saying. Alabama doesn't have a problem with what we're saying. And so the court's order shouldn't sweep the whole country. And so it was really a challenge to this idea of whether one judge in one court could bind the whole country. And the door swings both ways. I mean, during the Biden administration, the administration wanted to unilaterally cancel or reduce student debts. And so a different group of states went to a certain district in Texas where there's only one judge, so they know the judge they're going to get. And they sued in that court, and the judge said, you can't do that for the whole United States. And so at the time, states that were on the opposite side, perhaps, of Texas, in the current birthright citizenship case, were saying, hey, you can't do that. That's not fair. Why should one judge in Texas say what we're doing here on the East Coast? So that door's kind of swung both ways. And so they went to the Supreme Court and just said, we don't think judges have that much power. Traditionally, you go to court, whoever's in the court case, you're the one who gets the benefit of the ruling. If you have, let's say, unless you create something like a class action where you sign up a bunch of people who are going to be part of the lawsuit. And the Supreme Court looked at that question, and they agreed. They thought, well, at least for individuals, you really need to pursue like a class action. You need to join the lawsuit, be part of the class. So that way, if you lose, then you lose and you've lost the case and you can't do a do-over. Whereas with the statewide or national injunction, you may not have to join the lawsuit. If someone loses that case in California, well, then someone else will file a new suit in Michigan and another suit in Rhode Island. And so the argument the Supreme Court said is that you could just have more cases than you really need. They treated the states a little differently because the states were seeking relief for themselves. They're saying, this is going to cost us a lot of money. And Supreme Court says, yeah, that's a good point, but we're going to send you back to the first court and let them decide, is there anything they can do to narrow the scope of the order? And in all of those cases, the judges said, no, you can't. Because what happens is that people travel in the US. So someone comes to Vermont and they were born in Oklahoma. Are they entitled to Dr. Dinosaur? Well, it used to be, well, an Oklahoma birth certificate was enough. Now it's not enough. So it just kind of creates chaos. So ultimately, in practice, the nationwide injunction is still there, because in the private lawsuit context, the day the Supreme Court issued the decision, new class actions were filed that said, okay, we're representing all babies born on or after February 20th, 2025, who fit the executive order, and those have been certified. And so it hasn't made a practical effect, but the Supreme Court only looked at that remedy, not really the merits. Although there were a few justices who really wanted to get into the merits, I must add.
But Julio, am I correct in thinking it's a lot harder to put together a class action suit compared to, um, just an individual plaintiff in a district court?
It can be. It depends on the type of case, and there are definitely more hurdles to doing that. That's for sure. States are somewhat in a slightly different boat, because the class action mechanism doesn't really apply as easily to the states. And the Supreme Court recognized that, what we're saying is more likely to have an impact where states aren't suing the federal government. But that's true. It is more burdensome. And one of the concerns by several of the justices was, if you have this remedy and you lose, there's a class action, let's say it just covers people that are born in the state of Arizona, and that's it. That's all you could get.
Mm-hmm.
And you lose that case, there would be no incentive for the government to appeal it, because then you would have to the Supreme Court at least, because then you would have an authoritative ruling that would cover the whole country. Mm-hmm. And so there was a lot of worry that what the Trump administration was trying to do, seeking to limit this remedy, was just force people to go to court hundreds of times. Mm-hmm. And they would lose, and you'd only lose for these 50 or 100 people or 1,000 people, rather than lose once and for all. But the Trump administration, when they were arguing, said, "Oh, if we lose one of these cases, we're definitely taking it to you," and that seemed to be good enough for the justices. And they've kept their word. They have in the West Coast case, they have already petitioned the Supreme Court to review it on the merits, and I expect that will happen with our case as well. So yeah, there definitely are more hurdles. But I think that, especially like for the states that have been challenged Trump administration, I don't feel like we've lost a step. I think we are, we brief the cases, I think, with a little bit more detail, a little bit more evidence, but we always go in showing the injury to the states and articulating why we need the kind of order we're seeking. So I don't know that it's affected, the state of Vermont and these other states that join us in these challenges.
Julio, how many birthright citizenship cases are out there? How many are pending?
It's hard to, I would say, let's see, one, two, I think some of them are addressing only pieces of the executive order. There are 5 that I would say are square on full attacks, frontal attacks. There are 2 sets of states. One, again, is on the West Coast in what's called the Ninth Circuit. We're in the First Circuit. Then the Massachusetts case is a nonprofit. There's another case that's filed in New Hampshire, another case that's filed in New Jersey, or I'm sorry, Maryland. So yeah, it's about 4 or 5 different cases.
And you've mentioned states as plaintiffs in these cases. You've mentioned nonprofits. What kind of nonprofits are plaintiffs in these cases?
They tend to be immigrant advocate groups, or they could be, constitutional. So, like some, although not as prominently in these cases, but, the ACLU takes class actions.
Uh-huh.
We were co-counsel with the ACLU back in 2019 and 2020 when the administration was trying to put a citizenship question on the census. The ACLU brought a big class action, and that case was consolidated with the states. We went to Supreme Court and won for the Supreme Court. One of the organizations is known as CASA. They've been known as CASA for a long time, but it's an acronym. It's like Central American Support and Advocacy or something like that. So, and they go out and find individuals who are, pregnant parents, and then ask the court to say, this rule is so clear it's going to apply. It's just like, if you're a baby and you meet these criteria, you don't get citizenship. So it's very easy. It's a very easy class to define. That's opposed to something like an environmental class action, where it's hard to define, like who's harmed by air pollution that's coming out of a particular factory, or pollution that's going into a particular body of water. That's a little harder to define. So not all class actions are the same.
All right. And what else should I ask you, Julio? I think those were my
I don't know.
questions.
I see a couple questions in the chat I don't think I've looked at. Um,
I think there are two new ones I
yeah,
haven't. I'm
not all
sorry.
nations.
I understand not all nations have birthright citizenship. How do they define citizenship?
Yeah, so I mentioned this Latin term, jus solis, which is the right of the soil. There's a competing kind of historical theory of citizenship that's called jus sanguinis, or the right of the blood. So it's more based on your parents' lineage and on their immigration status. To varying degrees, more or less, almost all of the countries in the Americas, North, Central, and South America, follow you're born on the soil. There are some exceptions to that, but like all 7 Central American countries have the same rule that we have, that Canada has. But there are other countries that do not have it. I mentioned a few where the result is that you could have stateless children. But there are also some European countries that it's based on, maybe you are born on their soil, plus your parents have, this status or that status. So just kind of two different traditions. And, a lot of American law, especially constitutional law, is based on the law that we imported from England, as opposed to, say, France or Germany or Spain. That's the other theory. And that's just not something that the U.S. has ever really had, notwithstanding. The closest we've ever come to addressing that, it has to be with this kind of unique situation for the U.S. dealing with the Indian tribes. What do you do there? Because under our Constitution, the Sioux Nation is not quite like England and France, but it's also very different than Ohio. You see, it's like it's viewed as what the courts call quasi or somewhat sovereign authority. So that's the alternative theory, which I don't think applies here. That's what the Trump administration wants to have.
All right. And then here's kind of a next question is really kind of a child welfare question. If a baby is born in the USA and becomes therefore a US citizen, but the parents are not citizens and cannot stay in the United States, what happens with the child?
So it depends. Lawyers are prone to say that there are some exceptions in the immigration law where the parents can seek an exception for if the parents are otherwise subject to deportation, or what's called removal under the statutes, where the parents can seek an exception saying my kids are here. And they're pretty narrow exceptions, but that is a possibility. But what happens in practice? Foster families. If the family is not going back, then there's a foster system in all of the states. All states have usually through state refugee resettlement offices where they're foster programs, with the hope of then maybe the parents are removed or they're removed while their case is still proceeding. And so their parents are hoping ultimately to win their case. Let's say if there's, fleeing violence from a given country. But that's what happens with it. During the first administration, you might remember the whole nightmare during the first week or two where they imposed the travel ban and
Yes.
they were not allowing people to fly back. We had cases, including cases that touched on Vermont, where the family was returning from, like say they were returning from one of the blacklisted countries like Iran, and one parent is there, has a visa, another person has a green card, and they have 3 kids, and 2 are U.S. citizens, and one's a green card holder. And there were real, and I mean, it was really like fire drill kind of strategizing to figure out, like, when the plane lands, what are they going to do? Are they going to say, okay, 7-year-old, here you go, off you go. You can go to the curb at Logan Airport and get a cab or something, because we're going to hold your parents. It was really quite frightening and was ill thought out, and thankfully all of that had gotten blocked in the first week or two. But it is what we call it. I mean, it's a kind of quiet family separation. It isn't pulling kids and putting them in camps, but it is creating this terrible choice for the parents where they may have no choice in going back to their own country. And the question is, can I find somewhere safe for my kids? So hopefully I can survive long enough to get back here legally and be reunited. It's heartbreaking. And we all, we're doing a lot of work on these cases, you can imagine. But we feel like it's a privilege because the issues are really important. And, Vermont's very invested in that. And that makes us feel, really good about representing the state, because the whole state is really behind that effort of keeping families together, trying to grow our economy, grow our communities. We need kids in schools in Vermont, right? And we need to grow our communities. And so we all feel pretty lucky, even though we are working a lot longer hours than we did a few years ago, that we get a chance to do that.
All right. I'll ask again. What else should I ask you?
Um, I guess the question that I think I would want people who are listening to ask themselves is, how connected are you to Vermont's immigrant community? I live in Montpelier, and I know that in town every other week there's like salsa night, there's salsa dancing at Hugo's, where people who are trying to make a life for themselves in Vermont but come from different parts of the world are trying to find community. And I think are finding that among people who come from either a common culture, if not a common country, but are also just looking for community, with their neighbors. And I would encourage folks to reach out to those folks, because it's a very frightening time for them. And if they don't know you, they don't know whether you're cheering this on or not, because the bullhorn out of Washington is trying to suggest that you are, when I'm pretty sure you're not. And so I guess that would be a question for folks, would be like, are you connecting yourselves, and are you supporting organizations here that are representing immigrant families, during this very frightening time? Because we haven't really seen anything like with it. Now with all the militarized ICE operations that we see on television and social media, it's a very frightening time for everybody. And so In addition to doing this, this is my day job. I'm trying to be a better neighbor, and a better, and better Vermont community member to folks, and kind of expand my own circles.
Thank you, Julio, for adding that individual and community connection to this otherwise kind of theoretical talk. I really appreciate you bringing it kind of back home to our home. So thank you for that. And I don't see any other questions in the chat, and I don't think I have any others. So I'm just going to say thank you.
I will thank Julio and Paul for the discussion and the audience for their questions. And I hope that everyone will join us on December 10th, second Wednesday in December, when we will learn more about the history of voting rights in this country.
All right.
All right. Sounds good.